companies for surgeries and prescriptions recommended by their doctors. But the insurance companies have every right to conduct their due diligence. That's the view of workers' compensation attorney Robert Friedman. He joins us today from Fort Lauderdale. Robert, good to see you. Thank you for being with us.
Thank you for having me.
Robert, we hear instances of workers' comp fraud, but a study by ProPublica and NPR suggests that it's actually a much smaller part of things, that really a lot of the pullback by the insurance companies and the states has just become because of rising medical costs and rising insurance costs.
I don't think that's actually what's at play here. I mean, obviously that's a portion of what is going on, but during the segment with Ms. Perkins, one of the things that I heard about was the frustration with how long it was taking to get medical treatment. And there is a give and take in the workers' compensation system. I know that I represent employers, and one of the biggest complaints is that employees who get injured at work get workers' compensation benefits regardless of whose fault it is. It is a no-fault system. And the employers feel that when they're giving up the right to contest liability in a workers' compensation claim, they have the right to do things like investigate medical treatment. So in this particular case, the opinion of one doctor that surgery is needed is really just that, the opinion of one doctor. As we all know, reasonable doctors may disagree as to what appropriate treatment should be. So the insurance companies have the right and should have the right to do additional medical investigation to see if there are other opinions as to what medical treatment would be appropriate. In many cases, surgical intervention is premature. I can't speak to Ms. Perkins' case, but I do know that that is how the insurance companies view these types of claims.
We looked, and we didn't look very hard to find a few people where it did seem unreasonable that they weren't getting medical care for injuries that took place on the job. There's a story of a McDonald's worker who went to the aid of a customer and was denied coverage because it wasn't in the normal course of his duties. This stuff feels kind of dirty.
Well, I think that what ends up happening is we hear only part of the story, and I know that there are situations that occur where we hear that he was defending a customer, but we don't know the whole story, and I can't really speak to that particular situation. There are a variety of circumstances that can lead to why a claim is denied, why it is determined that somebody was not in the course and scope of the employment. The facts of that particular matter would dictate whether that person was in the course and scope of their employment. It sounds like it went through the legal process and a determination was made that they were not. So while we hear just some basic facts and it does seem unfair, or as you put it, dirty, I think there's probably more to the story that we'd have to get into to understand why that determination was ultimately made.
All right, well, in the ProPublica story, for instance, there was a gentleman who was very clearly determined he was a derrick worker in North Dakota, and he lost the bottom part of his left arm in a workplace incident. His doctor determined that he would need a prosthetic with a working hand. The insurance company that was employed by the state sent him out of state to Minnesota to a doctor who apparently just does work for this insurance company and determined that he needed a hook, not a working hand. So again, and then there's probably a $50,000 difference between the prosthetic that had a working hand and the one that had a hook. So again, it was determined that it was a workplace injury, but they determined an outcome that was substantially less expensive, and that didn't give him the life back that he had for being injured on the job.
Well, I can tell you that in Florida, something like that probably would not fly. I know that insurance companies are businesses and they're looking to make economic and financial decisions regarding these medical claims, but the example that you just gave seems to be an extreme. It's not an example that I've ever seen or heard of, and I don't know if a court in the state of Florida would allow such a thing to occur. There is a process involved where we do get in front of judges of compensation claims, and those judges will ultimately determine whether things like that are appropriate. I don't think that I would ever see a case like that would be determined appropriate, but again, as you indicated, or as was indicated in the piece that I just listened to, every state differs, their statutes differ, and so what is permissible and allowed in another state may very well not be permissible here in Florida.
Let me ask you this, Robert, and I get your point that we'd have to look at each of these cases individually and on the merits. But let me show you a graphic that sort of indicates a bigger picture here. This is the premium cost to the employer per $100 of wages. In 1988, it was $3.32 per $100 of worker wages. That was the premium. In 2014, this is nationwide, according to ProPublica, $1.85. It's been cut in half, the actual premiums. Now, there's a lot of science, I'm sure, and you probably know it better than I do, about why premiums would be lower today than they were in 1988, but very little costs less today than it did in 1988. So how do we explain this?
Well, I don't know. The employers that I speak to, that I represent, don't see a reduction in their premiums. They are consistently seeing increases in their premiums. As part of my job, I am speaking to employers every single day. And one of their biggest complaints is that their premiums are going up when one employee gets hurt. And that may be the only injury that they've had in their workplace in 20 years. The minute that one employee gets hurt or that one employee files a claim, their insurance premiums go up, and in some cases they get dropped. These are fears and concerns that employers of every size, whether it's a mom and pop operation or a large corporation, all these employers realize that these claims are going to ultimately cost them money. And the problem is that for every case that you hear about where there is an injured worker who may not have been treated fairly, there is also a case of an injured worker who is trying to take advantage of the system, who is trying to manipulate the system, and even to some extent commit fraud. And those two are having a detrimental impact on these employers, the cost of their premiums. So it really is a two-way street on this.
Robert, good to talk to you. Thank you for being with us to share your view with us. Robert Friedman is a workers' compensation attorney. There is no question that most workers who file workers'